Hello there. Hi.
Right.
There we go. Sorry, I'm allowed
Good
to
to have you
start.
with us.
There we go. Excellent. I can start
We're
my
in.
video now and let me share my screen for you all. And I will talk to you for 10 minutes about your current rights, which is not very long because thankfully we have more than 10 minutes worth of rights, but I'll just aim to go through the current situation and then Ben can go on later to what might change. So, can you all see that slideshow? I don't know if I can hear any of you, but hopefully. So,
Yeah, it's up and
yeah,
running.
excellent. Your current rights. So, I'm going to focus mainly on possession, partly because that's what's mainly going to change, hopefully, in the year to come. So, possession at the moment, and this is obviously the big change that everybody's waiting for. Possession at the moment can be done under Section 21. And what that means is Section 21 of the Landlord and Tenant Act 1988. The landlord can serve a notice, and it's what's called a no-fault eviction. So what that means is the tenant doesn't have to have done anything wrong. All that has to happen is that a fixed term of the tenancy has to have come to an end, or there has to be a break clause in the tenancy saying that the landlord can serve a notice. The landlord can serve this notice 4 months from the start date of the tenancy onwards, depending on what the tenancy says about fixed terms. So, for example, if you had a 6-year fixed term, which would be very unusual, the landlord couldn't serve a Section 21 notice for 6 years. But what's much more common is maybe a 6-month fixed term or 1-year fixed term. And the notice must give 2 months' notice from the date of service. So, from the date it goes to the tenant must have 2 months. And then, if the tenant doesn't leave after the expiry of that notice, then the landlord can apply to court for a possession order. And provided they've done everything right technically, whatever the tenant situation, the landlord will be granted that possession order if they've ticked all the boxes technically. So there's essentially no substantive defence and there's no reason for the tenant to have done anything wrong. It's a very, very straightforward serve the notice, time's up, you're out, and then get a possession order and then get a bailiff to come and evict you. That said, it's actually very, very difficult to serve a Section 21 notice properly because there's a load of requirements, and over the years, more and more and more requirements have been added, which means that probably, like, this is a pure guess, but probably way over 50% of Section 21 notices that are served incorrectly, and there probably would be defences, but most people don't know what those defences are and don't have the energy to fight something all the way to a trial and risk a costs order against them if they lose. But really, to get the Section 21 notice right, the landlord must not have charged an unlawful tenancy fee under the Tenant Fees Act. They must have protected the deposit. They must have served a valid gas safety certificate, which means a signed one that was taken before the start of the tenancy. They must have served the how to rent booklet. They must have served an energy performance certificate. They must have an HMO license if they need one. It's a house in multiple occupation license, and whether you need one will depend in some cases from council to council. If an improvement or remedial notice has been served in the last 6 months on the property, so usually if the property is in a terrible state of repair or dangerous in some way and the council served a notice, then that could make the Section 21 notice invalid. Or likewise, if the tenant's made a complaint to the landlord about a repair issue and then an improvement or remedial notice is served before the first hearing, possession hearing, then again, that will be a defence. So there's actually loads and loads of defences to Section 21 proceedings, but as I say, they're not rigorously pursued. And that's because all you're doing is buying yourself time by pursuing them, because in almost all cases, the landlord can then put right whatever they did wrong last time and then just serve a Section 21 notice again, and then the tenant will have to leave. The only exception to that really is if there was no valid gas certificate at the very start of the tenancy, not that it wasn't served, but just it wasn't done and didn't exist, then that could be a kind of complete defence to Section 21 proceedings forever, but that's the only one really. So there's lots of technical things, but there's no substantive or human defences or defences to do with the tenant or how they're living their life or what they need. There's no reasonableness, there's no specific circumstances of the tenant. It's just, has the landlord done the paperwork correctly, essentially? And then there's the kind of substantive grounds for possession. for assured short hold tenancies. So the ones I've put in red, or the one I've put in red here, is a mandatory ground. And what that means is if you go to court, if the landlord takes you to court and makes out this ground, so they can prove that this ground has factually happened, then there's no defence. The court has no option but to make a possession order. So at the moment, the main commonly used mandatory ground is ground 8, which says that at the date of the notice, so if any of these grounds are used, the landlord has to serve the tenant a notice, like a Section 21 notice, but a ground 8 notice. And so they give them that notice, and there'll be a different expiry date depending on which ground it was. So at the date of that notice, and then the date of the first possession hearing, which will be commonly a month or so after the landlord starts the claim in court. So if the date of the notice and at the date of the first possession hearing, at least 2 months' rent is unpaid, then the court has no option but to make a possession order. There's nothing else that can be said about it. And it could be some of that rent had been paid back in the middle and then arrears had fallen again. So that's the most common mandatory ground. And then all the ones that I've put in green here are discretionary grounds. And what that means is that you can have a reasonableness defence. So the landlord, the court can only make a possession order if it's reasonable to do so in all the circumstances. And what that means is you can bring in all kinds of different arguments that you might not be able to bring in under a mandatory ground. So most common ones is ground 10, some rent is due at the time. Ground 11, persistent late payment of rent. So under ground 11, there could actually be no rent arrears owing at the date of the first possession hearing. But if you can show a rent statement saying the rent has been paid late for the last 3 years or something, then the court could still make a possession order. But the tenant could appeal on a reasonableness defence to the judge and say, yes, some rent is due, but for example, for the 3 years before that, I've always paid my rent on time completely, and my mother died, and it's just been an awful time for me, and I lost my job, but I'm going to be able to pay it going forward. And the judge can take all that into account and say, okay, fine, I won't make a possession order. So unlike Sections 21 and Ground 8, which are mandatory, the judge can listen to those things, and in my experience, usually will. And Ground 12, another section of the tenancy agreement has been breached. So that could be absolutely anything, really, and any condition of the tenancy agreement that's been breached. It could be, the tenant had a pet and I told them not to. But again, the reasonableness defence would come in. So if that pet is a really noisy dog that's biting people and disturbing the neighbours, and the tenant refuses to get rid of it, then maybe a possession order would be made. If that pet is a tortoise, then that wouldn't be reasonable in all the circumstances, and there'd be no possession order. And ground 14 is essentially antisocial behaviour, which again has a reasonableness element to it. And then some of the less commonly used grounds I've just included here because I think maybe we'll see some of these come up again when Section 21 goes. So ground 1 is that the landlord gave notice before the tenancy started and previously lived in the house. So the implication being, I guess, that they'd want to go and live there themselves again. Ground 9, that suitable alternative accommodation will be available for the tenant, usually provided by the landlord. Or grounds 13 and 15, which I've never seen used, but again, maybe landlords will come to when they don't have the options of Section 21, that the condition of the property or of the furniture in the property, if it's the landlord's furniture, deteriorated due to misuse by the tenant. I'm just going to quickly talk about pets because this is what everyone seems to be talking about in relation to the Renters Reform Act to be, can you have a pet? It just purely depends on what the tenancy agreement says. So often the tenancy agreement will say that you can't, or sometimes the landlord may agree, but that is to change to some extent. Deposit protection is a kind of interesting one because at the moment, a really, really big reason for the landlord to get this right is that they can't serve a Section 21 notice if they don't. So we'll have to see how this is dealt with. But the law says essentially that a tenancy deposit must be held in an authorised scheme, so under a specific deposit protection scheme. At the start of the tenancy, prescribed information must be given to the tenant. So what that means is basically where their deposit is held and information about that scheme. And then at the end of the tenancy, if the landlord wishes to make deductions. So, for example, if they allege that in breach of the tenancy agreement, the tenant has damaged the property in some way, then the tenant must agree those deductions for the landlord to be able to take them from this protected scheme. And if they don't agree, then the deposit protection scheme can decide, essentially, or the matter can go to court if elected at the beginning. So in my experience, the deposit protection scheme decides purely on physical evidence, so photos, emails, etc. And it's not very useful appealing to them on kind of legalistic arguments. So really taking photos as much as possible at the beginning of the tenancy and making sure there's a good inventory is a really, really helpful thing to do. It's important to say as well that if the deposit isn't protected under an assured short hold tenancy, then the tenant can make a claim against the landlord for their deposit back, and then a penalty against the landlord or agent in some cases of up to 3 times the deposit. And whether it will be 1 or 3 times will depend on various things, such as, is this a case where the landlord has just by mistake not given them the prescribed information, but it was really protected? If that's the case, it might be just 1 times the deposit that's given. Or is this the case where the landlord is kind of trying to make off with the money, or they're a professional landlord and should have known better? So there's scope there for getting some compensation back, but it's not always straightforward. You have to make a claim in the county court, and in my experience, the landlord will quite often counterclaim for damage items in the property, and then it just gets into this kind of awful case where before you know it, there's a 3-day trial and you're at risk of the landlord's legal costs if you lose. So good to know that it's an option, good to try, but be wary that, as with starting any litigation, it can sometimes turn a bit problematic. And then, because I have only 10 minutes and I'm really rushing through, what other rights do you have as a tenant? The rights that you'll continue to have, the rights under section 9A to 11 of the Landlord and Tenant Act 1985 is essentially rights to have your landlord do repairs for you, to repair the structure and exterior of the property, and to keep your home fit for human habitation. The right to not be unlawfully evicted. So I've just gone through all the different ways that the landlord can lawfully evict you by applying to court. If the landlord turns up at your house and changes the locks, then that's a criminal offence, and it's also a civil offence, which you can receive an injunction to be let back in your home and compensation for. Likewise, if the landlord turns off your utilities and electricity to try and make you leave, that will also be counted as an unlawful eviction. And harassment as well. So if the landlord comes and bothers you with the intention of making you leave, like threatened you, then that's also an offence that is potentially a criminal offence, and also something you can receive damages for. And your rights here are essentially to take civil action yourself, or to report them to the council so that they can take enforcement action on your behalf. And I think that's my 10-minute whiz through. Done.
Great, thank you so much, Eleanor. I really appreciate it. You've been doing this for us for a number of years now, so every time I hear it, it's that there's always the clarity of transferring complex legal positions into something that any renter can understand. Because if I can get it, then anyone can. I think is the important test. So really, really useful stuff. We'll get to questions later, but if you think of them right now, that's not a problem. Put them straight in the Q&A, and we'll come to those after we've heard from our next speaker, and after I've told you a little bit about what we're doing on the current legislation going through Parliament too. So thank you so much again, Eleanor. Now we'll turn to James Bull, who is the Assistant National Officer from UNISON, the trade union. We've been working with UNISON over the last year to try and make sure that we can champion renters' rights, that we can tackle housing insecurity while also tackling employment insecurity as well, because the two go hand in hand. You need a living wage and you also need a living rent, or it's not worth so much in the end. But really pleased to have James with us to tell us a little bit about trade unions, about workers' rights, and what trade unions could do in relation to housing issues for their members too. So over to you, James.
Thanks, Ben, and good evening, everyone. So what can trade unions do to help members struggling with housing issues? Fundamentally, a trade union exists to protect your and improve your pay terms and conditions at work. But housing is an issue, obviously, outside of work. What can we do to help with that? And on a one-to-one level, most unions do offer a range of legal and financial advice services that members can access as part of their membership. These can be invaluable, obviously, for people dealing with a housing issue of their own. And we often will offer hardship funds as well for those members who are really struggling in extreme circumstances. But beyond that, what can the trade union movement do to address the big picture, tackling the housing crisis directly? So UNISON, the union I work for, we represent members across all public services, so members in health, education, local councils, and more. And we support them in two ways, primarily. We negotiate and organise in the workplace, regionally and locally, but we also campaign and lobby for changes and improvements that we want to see to government policies and to the law. And housing is a huge factor in both those cases. It's a workforce issue for us, but it's also a citizenship issue for us. And for our members across all public services, the housing crisis impacts the services that they deliver. And an example of that would be in local councils, where there are some real struggles to recruit into some vital roles like waste and refuse workers, social workers, care workers, and that is, of course, linked to low pay. And if we consider that housing is usually the highest or one of the highest outgoings that an individual will face, then it's impossible for us to ignore that direct link between services, low pay, and the housing crisis. So that's why it's become very important for unions to address the housing crisis directly, because it's hurting our members and it's hurting the services that they actually deliver and services that we advocate and champion. In addition, we're the lead union for housing workers in councils and housing associations. And we know our members are struggling from that aspect, from the delivery side, due to things like the lack of homes for social rent, ongoing cuts to public services, and growing waiting lists of people in housing need. And we gather a tremendous amount of data from our members to demonstrate that. We regularly survey our members across the whole public sector workforce and within housing services itself. And that gives us some very valuable data on how the housing crisis is directly affecting those workers, both personally and professionally. And just a few examples from a recent survey we did, we know that about 49%, so nearly half of our members rent from either private landlords or housing associations and councils. So that's a significant number and significantly more than the national average across the whole workforce. And for renters, when we drilled into that data, for renters in particular within our membership, we found that some of the big issues that they flagged for us was overcrowding, not living near enough to the place they work, not being able to afford to live near to where they work, and the quality of housing, and the value for money of that housing. So we'll often work from a campaigning perspective with charities and campaigning organisations like Generation Rent, as Ben just mentioned, within the housing sector to both analyse and present some of that data and the views and feelings of our members in public services, and use that as a basis for engaging with stakeholders like politicians, housing providers, and others. And that's where we have been and how we have worked for the last few years, really. We've developed some really good resources based on that member data that we've accumulated, reports. We have a housing manifesto, a UNISON housing manifesto that sets out a lot of this data and our positions on that. And it's been a struggle over the last 14 years because, of course, we've been dealing with a government that have had a very specific view, a very limited view on housing and the housing crisis. And we've now got a bit more optimism with the new Labour government and their approach to housing. But of course, we still want to see the detail, and we hope to see more of that soon. Things like funding for new homes, particularly for social rent, that's a top priority for us as a union. Reforming, and we would want to see the ending of the right to buy. And crucially, linking housing affordability to the cost of living, not to market values, which is a big mistake we feel that the last government made. And ultimately, to see a move away from a situation where most government housing policy is focused exclusively on homes to buy. And our view is that's why the last government failed, perhaps deliberately failed, to resolve the housing crisis, because so much of their policy was focused on home ownership as the only viable solution to the housing crisis. But overall, giving a voice to our members is one of the most important functions of a trade union. And our members who deliver public services but are often really on the sharp end of the housing crisis, it's about gathering information from them, from our members, and then using it to influence stakeholders so that we within the trade union movement can play what we would hope to be a significant role in improving the housing crisis and making sure that the views of our members are reflected when the stakeholders, when politicians are making key decisions around housing public policy. Thanks. I think I'll stop there. Thank you.
Brilliant. Thank you so much, James, for that. Really, really good to hear. I think I'm coming back. Yep, we're all coming in. So we're going to go to the Q&A shortly, but thanks so much, James, for sharing all of that information about the union and about that connection with housing. As you said, half of your members are private renters. In England, it's 1/5 of people in their homes are privately renting. So obviously there's a big link between people who feel the need or want to be part of a union movement to improve their employment rights, to also address this housing crisis that we're into. I myself am a proud trade unionist. I don't know if that makes me biased in terms of what I'm saying, but I think it's really important that people consider where they can get support and how to build the solidarity among ourselves to achieve the changes that we really need. So it's a pleasure to have UNISON on board with Generation Rent's mission on behalf of private renters as well. So before we go to the questions themselves, I'm just going to give a quick run through, a super quick run through, in fact, of the Renters' Rights Bill, which many of the people in the audience may have heard of. But if you haven't, it's the law that the Labour government has put forward in Parliament, and we're expecting, or they're hoping, in fact, will be passed into law itself by next summer. So it could be that this is the last really hard winter for renters, in which you're subject to arbitrary Section 21 no-fault evictions, like Ellie said, or you're suffering under some of the things that we don't yet have rights for. That could all be resolved with this new law by next summer, but there's still more to do with it until then. The history, as James pointed to, actually, in terms of the last government, is that we were promised a new law 5 years ago. We were promised the end of so-called no-fault evictions, Section 21. And we had promise after promise. We campaigned as hard as we could. We even had a law going through Parliament, but it was dropped just before the general election because it couldn't get through, mainly because backbenchers on the government side were resisting it quite intensely in the last year of government. So we're in a position where the Labour government's moved quickly on this. They made a manifesto promise to end Section 21, and they said they'd do that immediately. Immediately, unfortunately for us, doesn't mean on day one of government, but it means as quickly as they can in terms of passing a new law. So that will happen if they get this law through. They will replace Section 21 no-fault evictions with new grounds for eviction, though. So things that Eleanor was alluding to. So there'll be new grounds, which means that you can still sell your home as a landlord and evict on that basis. You can still move back into your home as a landlord or move your family in, and there'll be evictions based on that too. So it doesn't give us full protections if we've done everything right and played by the rules. What it does do, which is a massive success for Generation Rents campaigning, is it doubles the notice period if you are evicted from 2 months to now be 4 months. So it gives us that little bit of extra breathing space to be able to find a new home and hopefully make the savings that we need to make that move as well. And there's a protected period of 1 year as well, which is going to be introduced, which means that you can't be evicted through no fault of your own for the first year of a tenancy as well. So it gives you a little bit more security. We'd like to see that doubled as well, though. There'll be just whizzing through, there'll be a register of landlords for the first time. I don't know if you're aware of that, but seems crazy, doesn't it, that we don't even know who's a landlord in England, and there's no way of tracking that down. Most of us on this call, if you're renters, probably haven't met your landlord as well. So having that register will be really helpful to do a number of things with. There'll be an ombudsman, so someone you can take your dispute to. If you're having a dispute with your landlord, you can go to an ombudsman for private renting now. Once this law passes, that already exists for social housing, but it hasn't existed for us as private renters. So that will be a welcome new part of this too. Another thing in social housing is a decent home standard. So it sets minimum standards for the quality of your home to make sure your home is safe. Again, that will be moving to private renting too. We have far too many non-decent homes. About 1 in 10 of us is living with a potentially life-threatening hazard as a private renter. So to deal with that is going to be a huge boost to our rights. But importantly, you know those rights, because there'll be times, I'm sure, when you'll need to use them and make the ombudsman or your council aware of the issues. There's also things in the bill, the Renters' Rights Bill, about discrimination. So they're going to rule within the law that you can no longer discriminate against people based on the fact that they have children or they're receiving benefits if they want to rent from you. So a landlord will no longer be able to say, well, I don't want to take you because you're receiving benefits as a tenant. That's already basically the law in terms of the way that the courts have made various judgments over time, but this is just going to spell it out in a law that's set by Parliament, so it'll make it a lot clearer for everybody. They're going to ban bidding wars as well. So some of you may have experienced that. I certainly did when I was looking for the last time I was looking for a home. And it's when basically landlords are exploiting the fact that they get a queue around the block to try and get a tenancy, and then suddenly you get to the end of that queue and the price goes up, and they pit tenant against tenant in all sorts of interesting and awful ways. So that's going to be banned. So not only in the sense that landlords can't ask you to bid, but also in the sense that you can't actually offer a bid as well. So the asking price that a landlord puts a rental on the market for will then have to be the price that the renter has agreed at. So it's really stamping that out. And then finally, Eleanor mentioned already, but pets, there'll be a right to request a pet. It's not a right to have a pet. We're pushing for that right to be as firm as possible. So we need clear timescales in when a landlord needs to respond. We need to have a very clear and limited number of reasons for why it wouldn't be appropriate for someone to have a pet in those circumstances. We don't think landlords are necessarily qualified to make decisions that the RSPCA might know more about. So we want to make sure that it's just as easy as possible for people to bring their pets with them and stop finding themselves facing this awful situation where they're looking for a new rental home and they're having to choose whether or not to keep their long loved pet or able to get a new pet or whatever they want to do and not have the full enjoyment of their home at the moment. So hopefully that will come in with the new law as well and be as strong as possible. So those are just a few of the things. There's a lot more in there. That was like a flying visit, just in case there's any questions that people want to bring in about how we can strengthen your rights as well, and how Generation Rent and Anthony Gold and UNISON can work on those issues as well for you and hopefully with you. So we'll go to the Q&A now. Do put some more questions in the chat, but we're going to start with a question that's specifically pointed out for Eleanor, which is, how difficult is it to obtain a legal injunction against a housing management company or a landlord, and is legal aid available for this?
Okay, so an injunction is any court order to force somebody to do something or to stop somebody from doing something. So I don't know what kind of injunction you're thinking about, or if you could put that in. There's some kind of injunction. So in general, you can't get injunctions against the agent. Usually all your rights are against the landlord, and that's the person you can get injunctions against. And the most common kinds of injunctions that I would apply, that I'd get and that you can get legal aid for, are injunctions to make the landlord repair something. So that could be an emergency interim injunction to make them do it very quickly, or more commonly, an injunction at the end of a long court case, or an injunction to get the landlord to let you back in the property after they've unlawfully evicted you, or to stop you harassing them. And legal aid is available for all of those 3 scenarios, but not really for any other kinds of injunction.
Fantastic. Thanks so much, Eleanor. I'm just going to move to a question about renters' rights, in fact. So there's a question that's saying where can we get the best resource for rights around renting? I would say this, but check out the Generation Rent website. We've got a Know Your Rights part of the website, which basically, if you type in your issue, or you can click on the category, you can find the latest rights in England around if you're being evicted, if the landlord's raising your rent, if you've got problems with the conditions in your home, and whatever it might be. Hopefully we've got an answer for you on there. If not, and in fact, if you need specific support for your case, then there's a number of options. You can speak to Citizens Advice, for example, to get some advice on your housing issues. We've got Advice for Renters joining one of our webinars later this week. That's a great organisation to speak to. Or if you can, and if you've got legal aid, or if you have the money and resources to do it, then you can go to a solicitor firm as well and get support that way, through the likes of Eleanor's, Anthony Gold, or whoever you like to work with, basically. Another way in terms of receiving advice on your general situation, of course, is if you're a member of a trade union. I'm sure UNISON and other trade unions will be willing to point you in the right direction when it comes to that. Great. So I'm going to move on to the affordability question, because this has come up in a couple of questions. It's linked, really, but let's talk about if a landlord is upping the rent, basically, and what might be able to happen there. What recourse would there be? So it says, so the question here from one of our guests is, can you talk about the landlord's right to put rent up and what can be done to contend it? Does having ongoing unfixed issues impact it at all? Eleanor, are you okay to come in on this one?
Certainly, yeah. So at the moment, the landlord can serve a notice under the Housing Act 1988, and you can a Section 13 notice to raise the rent. And you can, if you disagree with that, go to a tribunal, and if that rent is higher than the market rent for the property in the area, then it couldn't be raised to that sum, and having ongoing unfixed issues would impact it in that way. Unfortunately, the problem at the moment is with Section 21, there's another way which rents are more commonly raised, which is that the landlord says, will you agree and sign this so I can raise the rent? And if the tenant says no, they'll say, fine, well, I'm going to serve a Section 21 notice and then just rent it to somebody else for more money. So usually that whole Section 13 process doesn't have to be used whatsoever. And that's the way it's done. And very frequently come across horrible situations where the landlord is just able to let the property again, even if it's in a terrible state, for even more money, because there's just such a high demand. So the landlord, yeah, in short, does have a right to put the rent up, which is quite wide anyway, but is limited. But with Section 21, that's the way it works. But that hopefully is to change, and then the market rent for the property will become a lot more relevant. And also with a slower turnover, if in renters, probably rents won't go up as quickly, I would imagine, because at the moment, because the landlord has the ability to just relet and relet and relet and raise the rent, every year or every 2 years, they will do so. So I'm hoping that the end of Section 21 will slow rent prices somewhat.
That's so true. That the wider context of Section 21 can't be ignored when it comes to rent rises. And the first tier tribunal, which is the way that you can challenge a rent rise, the new law and the Renters' Rights Bill is proposing that basically you put a ceiling on that market rent, as they call it. So it's the amount that a similar home to the one you're in is going for renting. So the landlord, if they raise your rent higher than that, then they won't be able to, you can challenge it basically, and they won't be able to raise it that high. It will come down to the market level. But that leads me on to saying the market level is obviously absurd for many of us. It's so high, it's so unaffordable, and it keeps rocketing higher and higher. So it's at the point where we're finding key workers. This is some work we did with UNISON. Key workers are being forced out of their communities. You're finding that teaching assistants aren't able to educate young people in certain areas. You've got hospital porters who aren't able to make sure that we're caring for the sick. You've got roofers that can't afford to live in the community that they're going to serve, where they're going to build these new homes that will ease the housing shortage that we have. And all of those issues make things so much worse all the time. So I wonder, James, if I can turn to you and just ask you in context of what key workers might be dealing with. What's the situation if someone came to you with these rent rises as a member? What kind of advice and support would you be able to give them?
Yeah, as I mentioned earlier, there's lots of financial and legal advice that members receive as part of their membership subscription for being in a union, and a lot of that is accessible right from the start. There's a few points about more specifically about being represented at an employment tribunal, where I think there's a bit more of a time lock on how long you have to have been a member. It's not huge, but for that more general stuff about that would relate to housing, they have access to most of that advice and support from day one, really. And as I'm sure people will know, sometimes getting that advice without access via a membership can be quite expensive. So that's definitely something that I think we see as a real asset to a union membership. For a long while, I think unions have perhaps not as well understood as they should their role as a sort of a signposting organization as well. And that's something we've got a lot better at now, is that in addition to that kind of direct support and advice, we've got quite good at providing further advice and support and directing people off to where they can get that with organizations like yourselves and others within the sort of third sector, within the charity space as well. So, and I think that, I suppose I would like to think that when members come to their union for advice and we're signposting them in addition to what we provide directly, they would hopefully have the confidence that the directions we're signposting them to have been a good, helpful ones that we vetted ourselves and make sure are giving people the best support and advice.
Absolutely. Thanks so much. Is this an issue you encounter much, James, in terms of key workers or employees working in those areas that we were clapping for just a few years ago on our doorsteps? You find that they're being squeezed out because of the housing crisis?
Absolutely. The research we've done and the analysis that we did of that, it really does paint a very bleak picture for some of the lower earners within public services, really struggling financially and with their housing situation. And we know it's a key issue for our members, not just because of the data, but because when we interact with our members, when we publish content on our website, in our magazine, and social media, housing always draws a high level of interest from our members. Some of the editorial content that goes out on our social media and on our website, the ones with the most comments on are often housing related. In fact, our editorial team came to me just the other week saying, have you got anything on housing? Because it seems to be such a hot topic for our members. They want to know what we're doing about it. They want to hear what we've got to say about it. So it clearly is a top priority for members working in public services.
Absolutely. Thanks, James. Just going to turn to a couple of questions on selling when a landlord chooses to sell the home. First of all, I'll point out that there is no obligation for the landlord to make an eviction if they're selling the home. That's a decision that they might make. It's a decision many do make because I suppose that opens to a wider market where you're not just trying to sell to people that are happy having sitting tenants when you do sell. The advantage will be with the new law, as I said, you get twice the notice period if the landlord chooses to sell, but they will still be able to evict on that basis. When they evict at the moment, in order to sell, then you'll likely get Section 21, as the questioner has said. But the thing about Section 21 is it's not only a no-fault eviction, it's a no-reason eviction. So they don't have to provide you the reason for which they're doing it. So they might not. We don't have a reliable record of how many landlords are choosing to sell, but we expect that would be one of the major reasons that you'd get evictions into the future with the new law. And then a related question is that I'll read it out, there seem to be fewer and fewer properties available, and a lot of landlords are selling due to the increased regulations. Surely more will do so when this bill becomes law. Do you have any concerns that this new law will make the availability and cost of property even worse for tenants? So from generation rent's point of view, there's a number of things to tackle with this sort of question. It's something that comes up a lot from the landlord representatives when they're engaging with the government on this. They sort of say, well, if you give renters more rights, we'll all just sell up, and then you'll have to deal with the consequences of mass evictions and not enough homes to rent. The thing with homes as we need them is, at the moment, as private renters, we're trapped between not being able to access social housing if we need it, and not being able to buy a home of our own if we want it, because we can't afford to for the majority of us. The homes that a landlord sells don't just fall into the ground. They're still there. Maybe it's a first-time buyer manages to get on the housing ladder and move out of renting. Maybe it's a council can buy it up as social housing. Maybe another landlord buys it and begins to rent it out to a new tenant. It doesn't change that much apart from the short-term harm of those evictions. So we're trying to put in as many protections as possible against the harms of those evictions as they happen. Another point to make would be that this end of Section 21, as it were, has happened in Scotland a number of years ago, and they've also changed it in Wales. So Section 21 also ended, but a similar law exists, although you have 6 months notice as opposed to 2 months. So those are changes to regulations that landlord representatives said would lead them all out of the market. It just didn't happen, basically. So a small number of landlords decide to no longer be landlords every single year. Some will choose that this is a moment too far, where renters have too many rights now and they don't want to be a landlord. From my point of view, that's absolutely fine. Those probably aren't the kind of landlords that we want if they're threatened by renters' rights. But also for many landlords, it's other factors that are causing them to sell up. A lot of them, actually, it's been recognised by landlord groups, are getting older and they're beginning to sell off their homes as part of their retirement pension fund that they want to do for themselves. And that's because these are landlords that got into the market in the late 80s or in the 90s when there was this first big boom in landlordism. And that part of that came from the 1988 Housing Act, which introduced some of the problems like Section 21, which gave a massive power imbalance in favour of landlords against tenants. So it's not the end of the world if landlords choose to leave. I'd be shocked if they left en masse to a point that was very different to Scotland and Wales that have already been through this change. So in many cases, it's a bit of an empty threat, and the government at the moment isn't really taking that too seriously, because they're so focused essentially on improving tenants' rights so that they can rip the band-aid off and we can't have that kind of threat in future that landlords will just sell up whenever we get new rights. Great. Does anyone want to add anything on landlord sales? Eleanor, is there anything you've come across in your work?
The same as you, really. People just sort of threatening in general that everybody's going to sell. Ultimately, many landlords never serve a Section 21 notice because they're happy with their tenants. You lose a lot of money when you get rid of tenants, and then you have to have an empty property and get new tenants. So for the vast majority of people who are happy, I don't think they'll be leaving. Landlords have been leaving for quite a few years. There was a big tax change which caused quite a lot of people to stop becoming landlords because it made it a bit less profitable, but it's still a very, very profitable investment to have if you have the money to buy a house or to get a mortgage for a buy-to-let property. There's not that many other lawful investments where you can be fairly, as sure of your return, basically, and still have a sort of relatively safe capital investment in the property itself, which can be sold at some point. So this isn't rent control. Whatever we might think about that, I don't think landlords will be leaving en masse.
Yeah, thank you. And James, are you going to come in?
Yeah, it's certainly something we've been having discussions on with stakeholders in the wider housing sector. And I think that it's easy to see that as a problem in the very short term from the landlord's perspective, certainly. But if you zoom back out and look at the big picture, I mean, I mentioned right to buy earlier, and really the right to buy caused the biggest transfer of public to private assets in housing history in this country, really, because so many of those tenants that bought their homes and were absolutely entitled to do so, then sold them on to private landlords further down the line. So if in fact landlords made the decision that it was no longer a lucrative business to be in, and did decide to sell up and move out of the housing uh, rental game, then we'd advocate for councils being empowered both financially and through legislation to buy up those properties. And if those did find their way back into the hands of local authorities, then actually looking back on the long run history of it, that's just a course correction, really, is moving those homes back to where they belong in many circumstances.
Excellent.
Yeah.
Thanks so much, James.
Yeah, and just one more point there. I mean, the more social housing there is, the more private rents will go down because there's less competition in the market, and the more people can buy their homes, the more private rents will go down as well. So any kind of, as Ben said, there's a certain number of houses, and if a different kind of person is filling that house, that doesn't necessarily mean that will cause rents to go up or that someone won't have somewhere to live.
Absolutely. Yeah. The way I put it is that we definitely need more homes, but we don't necessarily need more landlords as part of that. Absolutely right. So we're running short on time, last 10 minutes. So do get your questions in if you've got any more. If we aren't able to answer all of them, then please put them in an email to Generation Rent as well, and we'll hopefully get back to you in the coming weeks as well. So a question just on something slightly different is if a landlord has to do a lot of work on your home to address years of neglect, accrued maintenance. Are you entitled to any reduction in rent due to disruption to your enjoyment of your home? I'd add a side question to this as well, because a lot of the government push on climate change and tackling climate change as well as fuel poverty is thinking about privately rented homes as well, where we've got very poorly insulated homes a lot of the time. We've got poor energy efficiency, old boilers, all that sort of thing. So that requires some work by your landlord as well for a lot of people. When these works are going on, if it's causing disruption in the home, Eleanor, do you have a view on whether you're entitled to any reduction in your rent?
Not for a poorly insulated home or an old boiler, unless that poorly insulated home is causing mold to form and to make the property unfit for human habitation. If it's a repairs issue, so the structure or exterior or the facilities for water, gas, electricity is broken, so out of repair rather than just being old, or if something about the home is causing it to be unfit for human habitation, which means there's a health and safety risk, or it's uncomfortable to live there, like there's damp, there's mold, there's holes letting mice in, for example, the windows are drafty, something like that, then you're not exactly entitled to a reduction in rent by bringing a civil claim, but what you're entitled to is compensation, which is in fact calculated as a percentage of your rent back. So it is basically almost the same as a reduction in rent. Or if you live in an HMO, a house in multiple occupation, it might be that there's certain situations in which you might be able to get a rent repayment order, which is kind of a bit of rent back for a year for that period. But yeah, it depends what it is really, because if you just have a sort of like avocado bathroom from the 80s, but it's all functioning, then no, you don't have any right to compensation. But if that bathroom is moldy and leaking, then yes, you would.
Okay, really good to know. And what's the advice if someone was suggesting that they'd want to withhold their rent because they feel that the situation isn't right?
The advice generally is don't, unfortunately, as much as it would seem like a good thing to do, because your landlord will just issue a possession claim against you, and you don't really want to be on the position where you're having to counterclaim. You'd but much better in a position where you're in control and you're bringing the claim yourself. And also, you can't actually get legal aid if you've deliberately withheld your rent to defend that possession claim, which is a big disadvantage.
Okay, thank you so much. Question for you, James. This is one that I think it's worth getting into myself actually. Just before we wrap up, a lot of renters, myself included, we're working from home, especially since COVID. So some people working hybrid, some people always working from home. Do you find with the union that you're having any interaction between an employer and the home working conditions that the employee has, as opposed to when we used to go into offices a lot, because of course we're spending a lot of our time at work, but also in our home at the same time?
Yeah, it's unsurprisingly an issue that has become quite significant in the last couple of years, and employers and employees, I think, and to a degree, trade unions are still struggling with it a little bit because the world moved on far quicker than the law did, and even the arrangements that employers had in place. I mean, some employers had already moved to hybrid working before the pandemic hit, and they were quite well set up for this, and others were kind of dragged kicking and screaming into a new way of working. And what we tend to find with members is it's two issues really. One is this kind of concern about a two-tier workforce where, particularly in public services, you've got many jobs that can't be done from home because they require someone to be on the site, on the premises. Lots of jobs in the health service, education jobs, and even some jobs within local authorities and others. But then more office-based jobs, of course, can easily be done. So there's a question about a level of sort of equity across all workers within a workforce, that they all should have access to the same provisions, and how that's balanced out. And then the other side of it that comes up a lot is around the actual appropriateness, I suppose, and the conditions of where someone can work from, and how responsible is the employer for that individual's ability to work from home. Things like that, you know, if someone needs a screen and keyboard and mouse and the right kind of chair and a desk and other things like that. And there's a bit of a push and pull between what employers feel they can be and should be responsible for. So there's still a lot of work to be done on that, really. And I think that some of the new flexible working legislation that's going to be wrapped up in the new Rights for Working People bill going through Parliament is going to address some of that. But it's a complex issue, and it's still moving and changing now. And we're seeing a continued, as I said, push and pull between employees and employers on how that is all panning out. But ultimately, if you're a member of a union and you're struggling with that, your union should be your first port of call to defend and support you on that.
That's really interesting. Thanks so much, James. And if there are any employers watching, I'd implore you to think about the conditions that people are facing in their own homes, particularly those who are renting and facing some of the struggles that we have. Whatever the law says, it's usually a bare minimum of what you should be doing. So you can always do more as well. I think it's important to recognise that when people are working from home. So I'm afraid I'm going to have to wrap up, but thank you so much to everyone for your questions. Apologies for those who I didn't manage to get asked, but yeah, please do write to us. And if you've got an individual issue that you're working through right now, remember there are organisations out there that can support you kind of directly as well. So do make sure you get the right support that you need. Just moving on to think about the rest of the week, we've got a whole host of webinars, as I mentioned, lined up for you. So please do sign up to as many as possible. What I'd love for you to go away and do, if you've learned anything from today and you're on social media, is get on there, tag Generation Rent, and tell the world something that you've learned that you didn't know before about your rights as a renter, because that will really help to spread the word about some of the protections that we have, or some of the protections that we need, if that's what you want to talk about instead. There's other ways you can support us by becoming a member of Generation Rent. That's just giving us a monthly direct debit. Or we've got a crowdfunder going at the moment where we've got some awesome prizes in terms of signed books about the housing crisis, including Tenants by Vicky Spratt and Against Landlords by Nick Bano, both of whom I'm actually speaking with and interviewing as part of our Renters' Rights Awareness Week this Thursday from 6 p.m. So you can sign up to hear them talking directly about their findings in their books there too. But for now, it leaves me to say a happy Renters' Rights Awareness Week. Thank you so much to Eleanor and James for joining us and sharing your insights from Anthony Gold and from UNISON. We really appreciate partnering and working with yourselves on this area. And thank you so much to everyone at home for taking part. We really appreciate your support at Generation Rent, and hope you can tell your friends, your family, and everyone that you know that they do have rights, that we're making them stronger. But in the meantime, let's all look out for each other, because we will get to a place where renting can, must, and will get better for all of us. So thanks so much. Take care.
Thank you.